Welcome, everyone. Today, we're diving deep into a Supreme Court case that, well, it really makes you think about the whole system of drug warnings.
Yeah, it's a fascinating one for sure.
We're talking about whether a drug maker can be sued under state law for, say, not warning enough about a potential risk, even if the FDA, the Food and Drug Administration, was involved in the labeling process.
Right, so it gets into this whole area of federal preemption. Like, does the FDA's authority basically overrule any state laws when it comes to drug labels?
Exactly. And this particular case really boils down to a specific drug and a proposed warning about a particular type of fracture, a pretty serious one.
Yeah, these were atypical femoral fractures, or AFFs for short.
Right. AFFs, and they can be pretty nasty. So the drug company tried to get a warning about this kind of fracture added to the label, but the FDA, for whatever reason, wasn't on board.
Exactly. And that's where the whole legal battle started. The company basically argued that, hey, we tried to warn people, the FDA said no, so now we're being sued under state law for not warning enough. That doesn't seem fair.
So they were trying to use the FDA's decision as a shield, basically.
That's one way to put it. They claimed that the FDA's rejection of their proposed warning should preempt, or essentially override, any state law claims saying they didn't warn enough.
Got it. So walk us through what actually happened with the FDA. Did they straight up reject the entire warning?
Well, it's a bit more complicated than that. The FDA sent what's called a complete response letter to the drug manufacturer.
Okay, and what did that say, essentially?
It said they were approving the proposed warning about stress fractures, which was the specific language the company had used. But, and this is the crucial part, the debate centered on whether rejecting that specific term, stress fractures, also meant the FDA was rejecting a warning about the broader category of AFFs.
So the company's saying stress fracture, the FDA says no to that exact term. But were AFFs even on the FDA's radar at that point?
That's the million-dollar question. And it really gets to the heart of the legal arguments the Supreme Court had to grapple with. Were those two things, the stress fracture warning and a warning about AFFs, essentially the same in the FDA's eyes? Or was the company trying to use a narrow rejection to protect themselves from a broader potential liability?
It sounds like the justices really had to dig into the weeds of this complete response letter.
Oh, absolutely. They were scrutinizing every word, trying to figure out the FDA's intent and whether the manufacturer was being forthright.
And I'm guessing the whole question of responsibility came up too, right? Like, what are the obligations of both the drug company and the FDA when it comes to these warnings?
You got it. The justices were very interested in that aspect. They spent a lot of time discussing the FDA's duty to work collaboratively with drug manufacturers to make sure that the warning labels are accurate and clear.
So the FDA isn't just supposed to be a roadblock. They're supposed to be helping companies get it right.
Right. But on the flip side, the justices also probed the manufacturer's ongoing responsibility to ensure that their labels are up to date with, the most recent scientific understanding of potential risks.
So even if the FDA gives them the green light on a warning, the company can't just sit back and say, well, we're good now.
Exactly. They have a continuing duty to keep those labels accurate. And that's where this change being affected process comes in.
Right, the CBE. We touched on that earlier, but can you explain what that is exactly and why it was relevant to this case?
Sure. So the CBE process is basically a way for drug companies to update their labels without needing to go through the whole FDA approval process again. They can make changes under certain conditions, like if new safety information comes to light.
So it's like a fast track for important updates.
You could say that. And in this case, the big question was whether the company could have, or maybe even should have, used the CBE process to add a warning about AFFs, even after the FDA had rejected their stress fracture language.
I see. So even if the FDA didn't love their first attempt at a warning, the company might have had another avenue to get that crucial information onto the label.
That's exactly the argument that was being made. It gets to the idea that the manufacturer has a responsibility to act on new safety information regardless of the FDA's initial response.
And did the FDA's own investigation into AFFs come up at all?
Oh, for sure. The timeline of when the FDA started looking into these specific fractures was definitely a point of discussion. If the FDA was already investigating, it kind of weakens the argument that the company couldn't have known about the potential risk.
Right, because they could say, well, even the FDA is looking into it now.
Exactly. It sort of undercuts their whole, we didn't know, the FDA didn't tell us defense. And that's where the whole idea of low energy fractures came into play.
Ah, yes, that term. I remember seeing that in the case documents. What was that all about?
Well, it turns out the company had used this term, low-energy fractures, in their communications with the FDA, and they were seemingly using it as a way to describe these atypical femoral fractures.
Interesting. So like a synonym.
Well, that's what they were implying, but at least one expert disputed whether that was a really accurate or widely accepted definition.
So was this just a scientific debate about the best terminology?
Kind of, but it raised a bigger legal question, too. Should judges and juries be the ones deciding what these medical terms mean? Or should they defer to the FDA's expertise? I mean, imagine a courtroom where lawyers are arguing about the precise definition of a low-energy fracture.
Yeah, that would get pretty technical pretty fast.
Exactly. And it could lead to a lot of confusion and inconsistency. So there's a strong argument to be made that this kind of scientific debate is better left to the experts at the FDA.
It seems like a lot was riding on how the court decided this case. Were there any discussions about the potential impact, beyond just this one drug and this one lawsuit?
Oh yeah, the justices were definitely aware of the broader implications. They talked about how their decision could affect future cases involving drug labeling and preemption.
So what were some of their concerns?
Well, on the one hand, there's the issue of patient safety. Obviously, we want drug labels to have clear and accurate warnings so that people can make informed decisions about their health.
Right, people need to know the risks.
Absolutely. But on the other hand, there's also the concern about what some call overwarning.
Overwarning, what's that?
It's the idea that if drug labels have too many warnings, it could actually scare people away from taking medications that could be beneficial for them.
Ah, I see. So it's a balancing act.
Exactly. You want enough information to be safe, but not so much that it causes unnecessary fear or prevents people from getting the treatment they need. And the justices were wrestling with how to find that balance.
And they also threw out some hypothetical scenarios, right, to kind of test the boundaries of these arguments.
Oh yeah, they love their hypotheticals. For instance, they asked, what if the FDA explicitly rejected a warning about a serious risk because they simply didn't think there was enough scientific evidence to support it at that time? Should the company be off the hook then?
That's a tough one.
It is. And then they threw out another one. What if the FDA's concern wasn't with the warning itself, but just with how it was phrased? Would that be enough to preempt state law claims?
Wow, so they were really trying to think through all the possible angles.
They were. And in the end, their decision reflects that complexity. Remember, they didn't all fully agree on the reasoning.
Right, they concurred in the judgment only. What does that actually mean in practical terms?
Well, it means that all the justices agreed on the outcome of the case, which was to send it back down to the lower courts. But they didn't all agree on the specific legal rationale for that decision.
So it's kind of a mixed bag. They all agreed on what should happen, but not necessarily why.
Exactly. And that suggests that there's still a lot of debate and uncertainty about the scope of federal preemption in these types of cases.
Okay, well, I think it's time for our 10th chair segment. So imagine you're sitting on the Supreme Court, hearing all these arguments about drug warnings, preemption, and the FDA's role. What would your take be?
Ooh, okay. Stepping into the 10th chair here.
Okay.
I think, for me, the biggest sticking point is how broadly we interpret that initial rejection from the FDA. They clearly weren't happy with the stress fracture wording.
Right, but does that automatically cover all atypical femoral fractures?
That's the key question. It feels a little bit like the company's trying to use this rejection of one specific phrase as a get-out-of-jail-free card for not warning about a, arguably much more serious and well-defined risk.
So you're thinking they might be exploiting a loophole?
Potentially. And then you've got this whole CBE process sitting there. Even if the FDA had issues with the wording, the company had a clear mechanism to update the label with, potentially life-saving information about AFFs as the science developed.
So their responsibility didn't end with that first no from the FDA.
Right. To me, it seems like they had a duty to be proactive, to go above and beyond, to make sure those warnings were as accurate and comprehensive as possible. And the fact that the court only concurred in the judgment, well, that says something to me.
What do you think it says?
I think it suggests that there wasn't a clear consensus among the justices about just how far federal preemption goes in this kind of situation. And that lack of clarity, that uncertainty, well, it leaves the door open for more legal battles down the road. And it could make both drug companies and patients, well, a bit uneasy. It's almost like the court saying, we're not quite sure how to draw the line here. And that makes me wonder, if I were really in that 10th chair, whether the FDA's rejection was truly specific enough to prevent the company from taking further action.
So maybe there are some unanswered questions here.
Definitely. And it'll be interesting to see how this all plays out in future cases.
Well, that was a fascinating look at a complex and, let's be honest, pretty important case.
For sure. It really makes you think about the whole system of drug labeling, the balance between federal regulations and state laws, and ultimately how we protect patients.
Exactly. It's about lives and health at the end of the day, and that's why these cases matter so much. We encourage you, our listeners, to keep thinking about this. What are your thoughts on the FDA's role? Do you think drug companies are doing enough to warn about potential risks? How much power should states have to step in? These are questions worth pondering.